Forest Rights Act emerged actually from an interesting case in the South India. The case was filed by a person called Godavarman from Nilabur Kovilagam, who was at one time the Genmi of Gudalur region in the Nilgiris of Tamil Nadu. His case was that a particular land which was earlier the property of the family, which is now under the control of the government after the Janmam Act. I mean, Janmam was abolished. That forest was getting destroyed, and so he wanted the Supreme Court to issue an order uh, to ensure that that particular forest is protected. This case was filed in 1996. This has become very famous as a Godavarman case or the forest case. Sometime in 2002, the Supreme Court asked the Ministry of Environment, what is the government doing to prevent encroachment in the forest and to protect the forest? No sooner when this question was raised, what the Ministry of Environment did in May 2002 was that it issued a letter to all the states saying that all encroachments has to be removed within September 2002. That actually triggered off a huge violent eviction process across the country in which more than 100 people were killed. And according to the Ministry of Environment data which they provided in the Lok Sabha, between March 2002 to 2004, within a span of 2 years, more than 1,52,000 hectares of forest was cleared of all encroachment. So how many people were thrown out, nobody really knows, but roughly maybe up to about 3 lakh people could have been evicted. Now, the resistance to this eviction emerged, created the conditions for a nationwide movement of forest dwellers, and which subsequently went into a process of negotiation with the union government, which finally resulted in the Forest Rights Act being enacted in 2006. The first important point which emerged in this movement was what exactly is the issue here? Is eviction from the forest the issue? The response from the people was that eviction has always been there right from the period when the forest was getting colonized by the British government and subsequently by the forest department and the Indian government. That eviction has been part of their life, and they have been always resisting eviction, but it has never been solved. And therefore, resisting eviction was not going to lead to any solution. The only solution is to decolonize the forest, to create a democratic forest governance system. In other words, to bring the forest regime as under the tenurial governance right of the forest communities through the Gram Sabhas. So this was the proposition from the communities, which was subsequently was formulated in the form of a law. And fortunately, at that time, a village-centric or a people-centric democratic system, a law was already in place, which was called as the provision for the extension of the Panchayat Raj to the scheduled areas. So that created that there was a precedent of a legal frame of a democratic governance. So that frame was adopted for enacting the forest rights regime. This is the first important thing to be noticed. Now, the question was that the problem of non-recognition of rights is well known. It is well studied. The governments have always reported about it, that the process of recognition of rights when a land is being notified as a forest was not carried out, and it continued to remain unsettled, and therefore there was a gross injustice. This was acknowledged by the Ministry of Environment in the same Godavarman case in July 2004. And therefore, the government's position was that we want to solve the problem, we know what the problem is, but then what is the method? This was the question. The people's answer was very simple. They said that in our village, we know who are our people in our village, what are they doing, what access they have of the forest, how they are accessing, who are the people who are doing wrong things. All these things are only known to us. The problem of rights recognition, the problem of governance is simply because people who do not know what is the ground reality, who do not know about the forest, who do not know about forest rights, are the people who are being given responsibility to recognize rights and to govern forests. So it is the right thing in the wrong hand, and therefore the intention originally in the colonial forest legislation was not forest protection but revenue extraction from the forest, primarily those days from timber. And therefore the counter argument or the proposition of the communities was that all that you have to do is that hand over the recognition of rights, the authority to recognize right to the people who know about this, that is the communities at the Gram Sabha level, and to give the forest dwellers the responsibility to protect the forest. So that is the only way you can address both the forest rights and the issue of forest protection. This is the second point. The third thing is that how did this get reflected in the Forest Rights Act? None of the laws existing in this country ban deforestation. The Forest Conservation Act is the law to regulate deforestation, meaning that it permits deforestation, it regulates deforestation, it gives forest clearance for deforestation or the use of forest lands for non-forest activities. So this is the Forest Conservation Act. The only law in this country which bans deforestation is the Forest Rights Act, because under the Forest Rights Act there is a provision called the critical wildlife habitat. That is any particular part of the forest which is very important for any wildlife, for any particular wildlife. If it is to be protected, made inviolate, meaning that it's not, I mean the forest is not violated, then there is a provision, and that provision is, according to the provision, if that area is notified as the critical wildlife habitat under the Forest Rights Act, it is made it very clear that if an area is notified as critical wildlife habitat, it shall not be diverted for non-forestry purposes by anybody. So the government loses its authority to divert, or anybody loses its authority to divert a part of the critical wildlife habitat for non-forestry purpose. That is the only law. Interestingly, this law, which should have been operationalized and carried forward by the Ministry of Environment, only in 2018 the guidelines were notified. Till today, no forest land is notified under the critical wildlife habitat, indicating very clearly that the union government and the Ministry of Environment is not ready to ensure that a particular patch of forest which is most critical for wildlife is not diverted. They are willing to divert every part of how much ever important it is for wildlife to be diverted. So this is an evidence that the authorities are not interested in, committed to an absolute protection of at least the critical areas in the forest or the wildlife. This is one. The other thing is that if you look at the Forest Rights Act, what is very interesting is that one, the Forest Rights Act clearly states that the law is enacted to recognize and vest forest rights on forest dwellers. In other words, the law recognized and vested forest rights, and it provides for a procedure to demarcate, identify, demarcate, and record the rights which are already recognized and vested by the law in 2006. This is number one. Number two is that who are the people who are responsible to determine, demarcate, and approve the forest rights? It is only the Gram Sabha, because only they know who has got what rights, to what extent, where. The second thing is that within this is that the rights are three typologies of rights are there. One is the individual rights to housing and to self-cultivation. There is a limit up to 4 hectares. Then you have community rights. What is community rights? Anything that you can think of, whether it is written in the law or not written in the law, except hunting. That is the overall definition. And these community rights if you look at it, like for example, minor forest produce. If people are collecting minor forest produce, the only way they can sustain the collection of minor forest produce, progressively increase the collection and become better off. The only way they can do that is by protecting. When the forest is protected, can you have minor forest collection, improve the minor forest collection. It's the same thing if you're doing for grazing. Cattle grazing in the forest, when that right is recognized, it is natural that for people to continue grazing, to have cattle grazing as an important activity, economic activity, if that is to be continued, the grasslands or the grazing capacity of the forest has to be improved, and therefore they would have a vested interest in protecting the forest. So the community rights is the most critical component which can ensure that these communities have a higher stake. Right now, it is the state problem. It is somebody else's property. That is the situation. Once it becomes their collective kind of interest, then you will see the whole dynamics changing. It's already changing in many places. That protection becomes the only key reason for the community's insistence on community rights. Then you have the third category of right, which is the territorial right. That is, every traditional and customary boundary of a village is to be identified by the community, and it falls within the jurisdiction of that community. And when you say it is under the jurisdiction of the community, there is a special, in fact, in Forest Rights Act, the provisions which goes much more deeper is in relationship to conservation. There's a thing called Section 5. Under the Section 5, the customary territory, the community is to protect, manage, regulate the forest, wildlife, and biodiversity. It is not the forest department. It falls under it also requires the Gram Sabhas to protect the water catchment areas. It requires the Gram Sabhas and the forest rights holders to have what you call collectively protect the habitat rights of that particular region. So that is the provision in the law which is explained much more in the thing. And in order to protect this, every Gram Sabha in the law clearly says that every Gram Sabha shall have this customary territory. If there is by any chance, in the unlikelihood of any village not having a customary, logic is that every village has a customary territory. If by some fluke, if there is no customary territory, then the district authorities have to explain why that village does not have a customary territory. That is one. The second thing is that once you have that customary territory, once you have what is called as the community forest resource rights, then the Gram Sabha is to constitute a committee, a management committee, and that management committee will be the executive arm of the Gram Sabha in regulation, in deciding who in the village can do what in that particular territory. And the management committee has to work out a management plan which the Gram Sabha is to approve. Once it is approved, it is the Gram Sabha's authority or power to integrate it with the working plan of the forest department. And while integrating, if there is some component of the forest working plan which is not in tune with the Gram Sabha's plan, then the Gram Sabha has the power to change that part of the working plan also. So these are the basic elements which fall under the Forest Rights Act. One of the very important thing that one needs to understand is that what is the implications of Forest Rights Act, what it actually does. All that it does is that it transfers the colonial forest regime from the authority of the state through the forest department. There is a transfer of power to the local communities, and in a non-centralized pattern. That means that hundreds and thousands of villages becomes the statutory authority to manage their own forest patches. This is the frame. That these territories has to be determined by the community. The governance has to be done by the people. This is something totally new in this country, because we are used to assuming that it is the bureaucracy, the colonial administration, that is to take care of all our life in day-to-day matters. This is the particular notion. So there is a problem in internalizing this new kind of democracy, both within the community as well as within the bureaucracy. Just to highlight, two random incidents. In Jalpaiguri, in West Bengal area, the communities had not even filed forest rights claim. Now the forest department comes to the village and says that under our working plan, we have marked out certain trees and those trees are to be cut. So the people said, no, don't cut the trees, it is required. So they resisted and they prevented the forest department from cutting down the trees. Now the forest department went and complained to the police saying that the government officials were prevented from doing their duty. So under those provisions, the people and cases have to be filed. Cases were filed, people were arrested. Then it came to a question of bail. So in the bail application, when the bail was being argued, the collector explained the Forest Rights Act. So then the judge asked a question, oh, if that is the case, if this is the law, then the officials are not the forest department, it is the Gram Sabha. So therefore no case is made out. So the case was dismissed. Not the bail was, the case was dismissed. This law, this judgment did not get immediately internalized within the bureaucracy, within the forest department. The forest department again went to the same place, again wanted to cut the trees, again people blocked. This time these officials went to the police station and said that, look, the people have again prevented us from doing our duty. Now the part the police said was that, looking at this judgment, they said, look, you have to do you seriously want to complain? Now the issue is that you are not the officials, it is the Gram Sabha who is official. They say that the trees are not to be cut and you are going to cut the trees, then you will be the people who will be arrested. So decide whether you want to file a complaint or not. This is one example. In another example is, Gadchiroli district in Maharashtra. Now Gadchiroli district in Maharashtra is often referred to, even in official corridors, as one of the most successful district where Forest Rights Act has been enacted. In fact, in some states like Orissa have even sent their officials to study how Forest Rights Act has been implemented in Gadchiroli. Many studies or researches have been done in terms of the success of Gadchiroli, what has happened in Gadchiroli, how Gram Sabhas have taken control over the forest, the access and use of the forest, how Gram Sabhas have federated and are doing even commercial ventures using forest-related resources. Now, Gadchiroli is quite famous across the country for one reason. That region is one of the richest region to produce what you call as tendupata or kendu leaves, or what you call as the BD leaves. Now, the extent of leaves that are harvested there from that particular region runs in crores. Now, interestingly, when the Forest Rights Act was enacted in 2006 and when it was operationalized in 2008, Gadchiroli already had a movement which was generally known as, in Hindi it is Hamare Gaon Mein Hamara Raj, meaning that in our village it is our rule, our governance. So that was a very popular movement, and that had spread across Gadchiroli. So when the Forest Rights Act was enacted and when the people came to know, they understood the law from the idea of self-rule or self-government. So unlike in other places, they immediately absorbed it in that framework. And for them, when you say self-governance, the first simple logic is that now they are the ones who is responsible for the forest, that the forest which they were traditionally using. So it is their job to take over the forest, to make use of the forest and to protect the forest in whichever way they want. And Tendupata was one of the major source of income. The traditional method of harvesting of Tendupata is normally the forest department gets the forest contractors. This is, it's given on contract. The earnings are then divided. Forest departments take a portion. Sometimes the police also get something. The Maoists also get a share. So there's a a sharing of the loot of the forest facilitated by the state. It is in that kind of a complicated context this communities take charge of the Forest Rights Act. So the first thing what they did was that they decided to negotiate with all the forces, whether it is the contractors, the forest department, to everybody else, saying that look, from now onwards we are the ones who will be controlling the forest, and so we will tell you what you should do. So to the contractors they said, you don't come here, you don't send your agent. When we want to auction the Tendupata, we will inform you. So it was managed like that. So they took over. So what was the normal practice which was adopted earlier was that at in a particular season the forest department used to set fire to the tendu, the trees. The reason being that once you set fire to it, in the next season there will be a thick growth, and that can be harvested. So to get a good harvest, a good revenue. So this was the idea with which they were doing it. And as far as officials are concerned, they are not talking about, they don't look at Tendupata from the forest in terms of long-term sustainability. They are only thinking in terms of during my transfer, I have been transferred, I am here for 1 or 2 or 3 years or whatever. During that time, I have to make sure that so much of resources is extracted. Some goes to the state, some goes to me, some goes to many other people. So this was the very idea. So they had to make sure that the next harvest is there. It should give some money. And the people were only wage earners, daily wage earners, and this was the situation. But when the Forest Rights Act, according to that, when the people took over, the first thing they did was that they said they banned setting fire for harvesting of, getting a higher harvest for the Tendupata. Their reasoning was very simple. They said that if you set fire, next year there will be a good growth. But if over the years, the potential declines. It is so now that this forest is under our control, it is better that we get less money tomorrow so that we will get more money the day after tomorrow and subsequent years. So they banned the setting fire of this is one example of the practice, change in practice which is leading to sustainability. There are also stories from these areas where bureaucrats were very skeptical about communities having the capability to protect forest lands. I do not remember exactly which is the place, but there was one district collector, a lady, if I remember right, she had shared this slide where with a lot of skepticism they recognized the community forest resource, community rights in a particular hill area, which was, the picture was there, it was completely brown, nothing, no green, nothing. And within a span of 2 years, she took another picture to see what the hill looks like. Now it looks fully green. So this particular bureaucrats, in many other training programs for bureaucrats, she would come and say, look, I as an officer was so skeptical about people's capacity to do things. When the forest department with so much of resources and power, etc., are not able to do, how can communities do it? This was my thinking. Now, my own experience in my own district, I have seen this transformation from one to one, and this is a very clear evidence that given the right or opportunity or possibility, if communities take control of the forest protection and forest conservation will increase. This is a second. The third element which you can see across the country in almost all the cases of forest diversion, whether it is the case of the currently running the Great Nicobar project, or in Chhattisgarh, the Hasdev mining block area, to many other places, you will find that the people who have fought and died and resisted the forest destruction, why? Because to protect their own livelihood has been the local forest communities. So one should understand that conservation and protection of forest is very much tied to which community has got what relationship with the forest. The communities whose livelihood is dependent upon the protection of the forest will want to protect the forest. The communities or sections of people whose profits depend upon the destruction of the forest, then they would always want to destroy forest. This is a simple commonsensical kind of a thing, and this you will see it getting played out in tiger reserves, the resistance to relocations, the argument that once we are out of the forest will degenerate. This argument, and in real life one can see across the country.